Hello everybody, I'm afraid this is a talk about tax, so I thought I'd wear a tie for once, like my tax colleague Kevin. I'm so rarely wearing one these days. I'm pleased I could still remember how to do a Windsor knot. Now, this vlog is in two parts. This is part one of a talk about tax treatment of payments to bring leases to an early end, either by surrender, i.e. a mutual agreement between landlord and tenant to end the lease in spite of the tenant's contractual commitments under the lease, or by the tenant exercising a break option, a contractual right already in the lease, enabling it to end the lease on notice to the landlord. Tax, I know, is boring apart from to a select few, but it's important to know about the tax treatment as, in the case of a surrender, it goes to cash flow and therefore should influence the financial terms of the surrender deal. And in the case of a break option, the issue for the tenant is making sure you're paying the correct tax on any break payments to the landlord to ensure that you satisfy those critical break conditions and retain the right to break. In this vlog, part one, I'll talk about VAT issues, and in part two, I'll do SDLT and briefly other tax treatment. Now, the VAT treatment of a surrender of a lease depends on whether consideration is paid for the surrender, and if so, who pays it. Where a tenant surrenders its lease to a landlord in return for a payment from the landlord, the tenant makes a supply of land to the landlord. Supplies of land are exempt from VAT unless the supplier, in this case the tenant, has opted to tax. So the landlord surrender premium is VAT exempt unless the tenant has opted to tax its interest, in which case the payment is VATable at the standard rate. With surrender payments by tenants, we need to distinguish here between surrender premiums and dilapidations payments. Now, it's common for a tenant to surrender its lease to a landlord and pay a premium to the landlord for the early get out. That payment is properly known as a reverse premium, as the money travels in the same direction as the surrendered land. Whereas with a traditional premium or consideration, the money is paid in return for the supply of land. But the situation as to VAT is the same as a surrender payment by the landlord. The tenant surrender payment is VAT exempt unless the landlord has opted to tax its interest, in which case the payment is VATable at the standard rate. With dilapidations payments, however, which are very common as part of a surrender deal, HMRC considers that these payments are compensation or liquidated damages which are outside the scope of VAT. No VAT is payable on tenant dilapidations payments to landlords, and it's very sensible to split the dilapidations payment from the surrender premium in the deed of surrender, as where one overall amount is agreed that covers both without a breakdown, HMRC says that a reasonable apportionment should be made and has warned in one of its briefings that if there is evidence of value shifting towards the dilapidations payment, the dilapidation payment could be subject to VAT, which neither landlord or tenant would want. Now, a lease surrender can be a transfer of a going concern, a TOGC, for VAT purposes if the normal conditions for TOGC treatment are met. So this would be where a tenant who has granted subleases surrenders the lease with the benefit of the subleases which stay in place. Now, a case like that would require consideration of the facts, but there's an opportunity in that scenario for that scenario to be outside the scope of VAT. No VAT payable on the surrender premium if both the surrendering tenant and the acquiring landlord have opted to tax their interests. There you could have a TOGC even though the interest is passing up from transferor tenant to transferee landlord rather than the traditional TOGC where the interest passes across in a sale. It's common to see break clauses in leases requiring tenants to pay the landlord a break premium if exercising a break option. There was a period of debate 2 or 3 years ago as to whether VAT was payable on such payments. A recent Scottish Court of Appeal decision, which should be regarded as persuasive towards the position under English and Welsh law, concludes VAT would not normally be due on a break clause termination payment, but if, as would be common, there is a landlord's option to tax in place, then VAT should be paid. And it's very important for the tenant to get this right, as it's usually a condition of the break that the tenant pays the break premium and any applicable VAT. So the tenant's break notice could fail for non-satisfaction of the condition if the VAT is not paid. That's VAT on lease termination payments. I'll do SDLT in the next shorter vlog, part 2. Bye for now.